Hi there, I'm Savannah Mexto with Mannor Law Group, and I'm excited to welcome you to another webinar Wednesday with esteemed elder law and estate planning attorney, Robert Mannor. All families know that in an instant, everything can change. But for parents of a special needs or disabled child, that reality can be even more terrifying. No two estate plans should be exactly the same, especially when it comes to protecting your loved one with special needs. On this week's webinar, Attorney Bob Mannor will discuss unique tools and considerations for your estate plan that can bring peace of mind to you, your family, and your child. Now, before I pass the mic, I'd like to cover a few housekeeping details. First, even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation, I encourage you to contact us after the webinar. Now today, if you have a general question during the presentation, please use the question box. We will save time to review questions during the webinar. If for some reason we don't get to your question, we will contact you after the presentation. Lastly, note that today's presentation will be recorded and the replay will be sent out tomorrow so that you can share this with family, friends, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Mannor Law Group have to say? Note that we're a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He's currently chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys Michigan chapter. Also, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome Attorney Bob Mannor.
Hi, folks. This is a really great topic, and we're going to get right into it. But one of the things I always like to point out on this is that there's a lot of technical language that comes out about when we're talking about special needs trust or a trust for a disabled child or someone that has special needs. And so I'm not going to use that technical language today. So you don't have to remember what a D4A trust is. We don't have to get into that. What I'm going to use is we're going to try to talk about it from a standpoint of understanding the different types and why we have them and what the purpose is and what the alternatives are and how to set one up. But I'm intentionally not using the technical terms. I will tell you, when I first started out many years ago doing special needs planning, it got so confusing, the difference between a D4A trust and other trusts. And so the idea is we don't need to memorize stuff, right? We just have to have a understanding of it. So I'm going to use terms that are going to be more common, and we're not going to use the legalese part of it here. So this is not a presentation to other attorneys. This is a presentation to the general public to say, okay, think about it from the big picture to say, what do we need? How do we do it? How do we protect our family? How do we protect our loved one? So we're breaking that down today into 4 basic topics. What's the purpose? Why do we need one? What are the different types? And this is really important, the different types, because people get confused on this and sometimes they won't do it because they think they've been told something about special needs trust that might not be relevant to them, because it's going to depend on the source of the money. Where did the money come from that we're putting into this trust? What's the resource come from that that special needs person is going to rely on for their future needs? What are there alternatives? Can we do something short of a trust? And absolutely, there's a great alternative that is fairly recent in the last few years. We're going to talk a little bit about, and then how to set one up. And I mean that in a big picture term, not just call us and we can set one up, but you've got options as to the logistics of it and how we actually word the trust, and whether it's a separate trust or whether it's part of your trust. And we're going to talk about whether it's part of your will. It doesn't even have to be part of a trust. It could be part of your will. So we're going to talk about those types of things to get right down to the specifics of what does it mean, what does it take, how do we do this. One of the things I want to point out, if you take away one thing from this, it is that it's not that difficult to plan for a child with special needs. It should be thorough. I would like a thorough plan. If you've ever met me, you know I want to think through all the details and I want to have a plan for everything. I want it to be thorough, comprehensive, and holistic. But it should at least be, it's not that difficult to at least put it in there, to put the protections in there, even if it's a simple will. So here's what I'm talking about here. Before we get on to the next thing, this is just so important. I've had many clients tell me that their attorney told them that they had to disinherit their special needs child, their adult special needs child, because, and this is, we're going to get into the very next point as to why you need a special needs trust, is they say, well, if you don't disinherit your special needs child, they're going to lose their disability benefit. They're going to lose their medical benefit. And we don't want them to lose that, so we just have to disinherit them. This is the worst possible answer. Now, ideally, I think we should really think about this and have a really good plan and a comprehensive plan and a holistic plan, and that's what I do. But even the simplest of will could have a provision in there. I've seen them in as little as 1 or 2 paragraphs that sufficiently protected, that allowed your child with disabilities, your child with special needs, to still receive their inheritance, to still have the benefit of their share that they would probably otherwise get if they weren't special needs or on disability. And it can be as simple as a couple paragraphs in a will. Seriously, even I think I've probably seen it in as little as 1 paragraph. So that's why it kind of drives me crazy when I hear that attorneys are telling people, oh, well, the best thing to do is just disinherit. Or, you know, non-attorneys will say that too. They'll say, oh, well, you can't have your special needs child as a beneficiary. You don't want them as beneficiary. You don't want them in the will. You don't want them in the trust. Leave it to the other kids and hope that they take care of their sibling. Well, that creates all kinds of problems, because we don't know that your other child will be here. We don't know that your other child might not get have health issues or get dementia, or that they'll move away to Alaska. We don't know that the other child is going to be able to do those things, and we don't know that they will do it. But even if we are 100% convinced, so I hear this all the time, we're going to leave everything to the one child, and that child is going to take care of the child with special needs. They've promised us that. Have they promised you that they're going to outlive you? Have they promised you that they're not going to get in a lawsuit? Have they promised you that they're not going to get divorced? Have they promised you that they're never going to get sick? That they're never going to have medical expenses? That they're never going to have financial trouble? That they're never going to have their business fail, they're going to lose their job, or any of those types of things? Because if that's your plan, to say, I'm going to leave everything to the one daughter and she's going to take care of my son, this is a really bad plan. It is really problematic, and it's so easy. I would like you to do a comprehensive plan. We're going to talk a little bit about that, but we can at least put the language in there, even in a simple will. Any attorney that drafts will, if you don't know how to draft that language, you shouldn't be drafting wills. And I'm being more aggressive today than I usually am about other attorneys drafting properly. But this is one of those things that if you don't know how to draft language to protect a special needs child who's on disability or receives medical benefits, you shouldn't be drafting wills, period. And it's problematic because there's lots of attorneys that say, oh, I'm an attorney, I can draft a will. But if they don't have just that basic knowledge of how to do this, they shouldn't be drafting wills. And so if they tell you you have to disinherit your child, or if your banker, or if your financial advisor, or if your cousin, or if your barber tells you you have to disinherit your child because of their special needs, they're wrong, period. So I hope I've made my point there. I think I've made that pretty aggressively today. So let's get really into the specifics of this then. So the first step, of course, is to say why. And I've hinted at this, right? I've hinted at it, and let's just restate it, because I've obviously made it clear in my little tirade there that the purpose is, if we leave money directly to a child who's on disability, at least SSI, a certain type of disability, or receives medical benefits, is on Medicaid, is receiving SSI, if they have any means tested benefits, in other words, they were disabled from birth, or they just they don't have the resources to pay for their health care, so they're on Medicaid, or they just have special needs and they can't manage it themselves, then the idea here is that we can still have them benefit from a share of the inheritance, or they can still receive the benefit from a lawsuit settlement, or if they had their own money, or any number of other things. And we can set it up properly so that they can still receive those medical benefits. They can still receive Medicare if they've been qualified for disability for a sufficient period of time. They can still receive Medicaid even if they haven't passed that period of time on disability. Medicaid is often a means-tested program. So how do we make sure that they've got access, that they have, that the money that they should be entitled to is available for their needs without interfering with those Medicare, Medicaid, disability, Social Security disability, any other means tested program, okay? And like I say, it's not that difficult to do. We're gonna talk about how you do it based on where the money came from, but the main purpose is to make sure that they can still qualify for disability. Let's talk about a couple other things. What is the purpose? Sometimes the purpose is because we know that child would not be capable of managing their own money because of their restrictions, because of their development, because of their ability to manage it. They are unable to. But let's talk about that, because this is really important, because a lot of times we have a child, just because someone has special needs, just because they have disabilities, doesn't mean they're not competent to manage it. There's a whole lot of people that are perfectly capable of managing money, but we can't get them the benefits that they need. We can't get them the medical benefits that they need. We can't get them the disability payments. We can't get them the Medicaid that they need if they're in control of the money. So sometimes it's not because we need supervision. It's not because we need to appoint somebody over the charge of it. It just says the government says we have to do that, okay? And so we got to think about that. It's not just because they're not capable. It's often because we need to get those medical benefits. We need to get those insurance benefits, the Medicare benefits, the Medicaid benefits. We need to get that money that we get in every week to cover our basic needs, okay? So what happens if we don't have one of these? And the answer is, you leave an inheritance. I've dealt with this so many times, where grandpa and grandma are really trying to do a nice thing because they've got a grandchild with special needs, and they say, you know what, we're just going to put them on as a beneficiary on my IRA, or we're going to put them on the will, and they're going to get 10% of the proceeds from my estate. And that's all they say. And or mom and dad put the kids, you know, on there as a beneficiary on their IRA or their bank account or their life insurance or whatever else it is. As soon as they receive that benefit, it's going to trigger with the Social Security Administration, which is going to trigger with the Medicare, which is going to trigger with Medicaid, and they potentially could lose all of that. They could lose their Social Security benefit for disability. They could lose their Medicare. They could lose their Medicaid because they're over asset, because many of these programs are means tested programs. They get an inheritance. Now, can we fix this? Yes, we can. Kids used to watch Bob the Builder. Probably some of you may not know who Bob the Builder is, but it was an old cartoon where the phrase was, can we fix it? Yes, we can. If that happens, we can fix it. I'd rather have it not happen. I'd rather have it not happen. And we're going to talk about it later, about how do you set this up, and what are the types of trusts, and what are the consequences of the different types of trusts, as to why it's better to set it up before grandpa dies, before grandma dies, before mom and dad pass it on through beneficiary designations or life insurance or whatever else, rather than having it go through the inheritance, go through the beneficiary designation, and then have to set it up. The consequences are significant and not good. We have a potential of losing a lot more of it. It's more highly scrutinized, and ultimately, if there's any money left over, it's going to go to the state. If the money goes to the child first, and then we set up the trust, then there's what we have called payback provisions. If it never goes to the child, if it's set up for the child before grandpa dies, before grandma dies, before mom and dad die, before aunt and uncle die, whatever it is, we can set it up so there's no payback provisions. Okay, so we're going to get into that in a second, but there are consequences to doing this wrong. All right. So that's exactly the next step here. What are the different types? So I'm going to say probably the most common type is going to be the third-party trust, and it's also the least complicated. So the third-party trust, what does this mean? The third party is someone other than the special needs individual, okay? So the third party could be mom and dad. Third party could be grandpa and grandma. Third party could be anybody. It's somebody else's money. So it's not the person with special needs money, it's somebody else's money. And they say, well, I want to leave something to Sally. Sally has some form of special needs where she's entitled to and able to receive disability and medical benefits. And I want to leave something to them. Great. They probably will need it. And the nice thing about the third party trust is it's for supplemental needs. Another term that people will use, and we often use this language, instead of calling it a special needs trust, we'll call it a supplemental needs trust, meaning that it is not supposed to cover the things that are already covered. I will occasionally have a parent come in that says, well, they've already got everything taken care of. They live in a group home. They've been disabled from birth. They live in a group home. They're 50 years old. They live in a group home. They get a check, which is managed for them every month. They get to work a little bit. They have this little job that they do. And this is, I'm using the parents' words. This is the way that the clients have been described this to me. And everything's all set for them. And so I don't want to leave them anything. And then I ask, well, how often do you buy, get clothes for them? How often do you take them out to dinner? How often is there an expense that you just say, oh, I'll take care of that, or you give gifts for them, or you take care of, or you take them on vacation, or you do all these other things? Oh, that's all the time. Well, what's going to happen when you're gone? Well, I guess they just won't have those things. Okay, well, maybe would you want them to have those? Well, clearly, because I do it now, I want them to have it after I'm gone. Great, that's what a third-party trust is. Okay, and there's an alternative to this we'll talk about in a minute. But the idea of a third-party trust is it's not to cover those things that are already covered. If they have housing, they have medical, they have their basic needs covered. This is to cover the things that aren't covered under their basic needs. All right, and so the third-party trust is somebody else's money that we're leaving for the person with special needs. Now, we can do it upon our death, or we can do it now. We can fund that, meaning put that money into the trust while we're still alive. We can see where it goes. We can have that set up for them now. I would venture an alternative to that, which we're going to talk about in a minute, which is the ABLE accounts. We're going to talk about those in a minute. So if it's in your lifetime, I would say if we're going to set aside money for it, we might want to consider the ABLE account rather than the third-party special needs trust. However, sometimes it's appropriate. There's just a reason why we're going to do it that way. So you can put money in it now, or you can have money go in there upon your death, like an inheritance, and all of that is perfectly good. So then what's a first-party trust? So the nice thing about third-party trust, before I go on to the first-party trust, third-party trust is less scrutinized by the Social Security Administration and Medicare and Medicaid and all the rest of them, less scrutinized as long as it's written properly. It's not as highly scrutinized as these other two trusts. So there's not as much burden of administrative burden. There's not as much red tape involved in it, okay? And the nice thing about the third-party trust, probably one of the best things about the third-party trust, is that it doesn't have any payback provisions. What is a payback provision? Third-party trust says, when this person with special needs dies, then you can direct where it goes after that. If there's any money left over when the person with special needs dies, you can have it go to their sibling, you can have it go to somebody else, you can have it go to potentially a charity under some circumstances. You can decide where it goes afterwards. The state doesn't come back and take whatever's left over. Okay, that's what payback means. So a third-party trust, you can direct where it goes after the death of the primary beneficiary of the person with disabilities or special needs. So let's talk about the first-party trust. First-party trust is it's already money that is in the name of the person with special needs. Okay, it's the person with disabilities. It's their money. Okay, so now we got this money. Now we're going to apply for benefits, or we were getting benefits, and now we get this money. Are we going to just lose the benefits? Is that the only option? So remember earlier, and I said, well, if this happens, if it wasn't done right, and grandpa left some money to a grandchild with special needs, we can fix it. And we fix it through a first-party trust or an ABLE account, which we'll get to in a second. So with the first-party trust, it's their money. Now, this can be set up by a court. This can be set up by a grandparent. This can be set up by a parent. The weird thing about this is kind of an interesting story, or at least I find it interesting. When Congress set this up many years ago, the belief is they made a pretty serious mistake that they just kind of didn't think it through and didn't get probably good advice from the special needs attorneys like me and others that do this type of a thing. And so they didn't allow the person themselves to set up the trust. It had to be set up by a parent, by a guardian, by a grandparent, by a court, and not by the person themselves. Well, a whole heck of a lot of people with special needs that receive disability, that receive medical benefits, a whole heck of them, a lot of them are perfectly capable of making their own legal decisions, of signing their own trust, of creating their own trust. And Congress forgot to put that in there, almost as if they thought if you're disabled, you don't have the ability to understand legal documents. And so that was a glaring error on their part, and we hope that it was just an oversight. Well, guess what? They fixed it finally. So this is one of the things I'm very proud of, one of the organizations that I'm very active in. So the National Academy of Elder Law Attorneys, and we were I think the NALA, the National Academy of Elder Law Attorneys, was the primary force in getting this law changed. I'm sure there was others, but my belief is NALA was one of the biggest ones that used our influence to lobby Congress, lobby the president. This was a few years ago, to get this signed into law, allowing for the disabled person themselves to sign their own first party special needs trust. So that is law now. So thank goodness, right? Because there's a heck of a lot of people, they don't need a parent to do this for them. They don't need a grandparent to do this for them. They don't need a court to do it for them. They are perfectly capable of doing it themselves and understanding it, and they have complete mental capacity. And it's almost saying because you have a physical restriction, you don't have the mental capacity to sign a trust. Well, they got fixed, thank goodness, right? So that's been for the last, I don't know, 4 or 5 years, maybe, I'm gonna guess. I don't remember what year that was passed, but for many years, the person themselves couldn't sign their own trust, okay? Now, here's the drawback of the first party trust. If there's any money left over, there's a couple of drawbacks. If there's any money left over when that person dies, that money is subject to what we call clawback or payback, which is the state can file a claim against it and take whatever money that they've paid out for Medicaid, for medical benefits, for disability, for any of those types of things. And they can get, often it's going to be the balance of the account, they'll take it back, okay? Because sometimes medical expenses are extremely expensive, right? And so it's like if you didn't have insurance, you went to the hospital and you didn't have insurance. Well, their insurance is Medicare, their insurance is Medicaid, and so there could be a payback of those things. That's the first party trust. The other thing about the first party trust that can get complicated is the Social Security Administration can be, let's just say, cumbersome. Cumbersome meaning that sometimes they are very difficult to work with, and they will try to deny benefits, or they do deny benefits, and we got to go through this whole system and this whole appeal process and try to get it to the right level to make sure they follow the law. The other thing about the Social Security Administration is they tend to change their rules with very little notice. And there was a series of rules that came out. So for years that we were having troubles with these first party special needs trusts in particular, because they constricted the rules. And then they came out with a broadening of the rules to make it a little bit more workable. And then all of a sudden last year, I think it was, then they came out with a new set of rules that hadn't taken effect yet, but they set out that these are going to be the new rules. And they were so unworkable. They even incorporated third-party trusts, which were never incorporated in some of these problems before, and they were so unworkable. And again, NALA and AARP and a lot of other organizations got involved in this, and the Social Security Administration silently withdrew those rules, and they just kind of pretended they never existed. So they never actually took effect. It would have been awful, terrible, unworkable if those rules had gone into effect. And so Social Security Administration sometimes does this type of a thing. And so don't take this too bad. We've got lots of folks that have first party special needs trusts. They work great. They're a fantastic solution. It's just that you need a lawyer. That's one of the things is with a first party trust, you're really gonna need a lawyer that knows how to work through the system, make sure you keep in the straight and narrow, and that's gonna be an ongoing thing. I've got some really good friends that are some of the top experts in the country, probably the top experts in the country, that advise families on these first party trusts and help them stay on the straight and narrow, help them stay within the buoys that the Social Security Administration says is the current law, okay? And so, but that's the idea, is it's not something that you can just do and then just, follow these rules. You're probably gonna need ongoing legal help as long as that trust exists. So that's the first party trust. The third party trust is not nearly that complicated. And then we have this thing called a pooled trust. And pooled trusts are really interesting. These are mostly for folks under age 65, where we start at under age 65. There is some complicated rules once it gets over age 65, so we're not going to get into this. So this is for folks where we're putting the money in there before they turn age 65. And the idea of the pooled trust is that we've got an organization that is running this pooled trust. So you put your money, so it's the first party, it's the special needs person's money, typically, it doesn't have to be, but typically, we put their money into this pooled trust. The pooled trust will then pay it out to them for their supplemental needs and their needs, and we apply for that, and they set that up as convenient as possible for them. But it also does have those payback provisions, okay? So in the event that they pass on, that money is not going to go to their heirs or things like that. So those are the three basic types. There's lots of other different things here and lots of nuances here. Like I said, I'm not going to get into the legalese of it or the technicalities of it. The next step is going to be the alternatives. I want to touch base on this quickly because a few years ago, I'm going to say maybe 6 years ago, probably about right, 5-6 years ago, federal government passed this law called the ABLE Act. And I will tell you, at the time, when I first heard about it, I was curious as to how this was going to work. And I will tell you, some of the politicians believed that they were creating the ABLE Act to be able to bypass attorneys, because prior to this, you needed to set up a special needs trust in a situation where we wanted to preserve our medical benefits and our disability benefits. And I'm confident that some of the politicians that was their primary motive here, was to say, well, they didn't like lawyers very much. They wanted to allow people to avoid lawyers and set up these ABLE Acts accounts and not have to do a special needs trust. And the more I looked at it, I was like, this is fantastic. Absolutely, let's do this. So I'm one that sets up a special needs trust, and I looked at it and I said, this is great. This is fantastic. This is going to be so helpful to so many people. The idea of the ABLE Act account. So let me give you the big picture here. The ABLE Act account is where you put money. It's similar to a 529 plan. So if you know parents that have set aside money for their kids and they put it into a 529 plan for college. So they're setting aside money aside for their kids or grandkids with the idea that that money is going to be used for college. The person that puts the money in gets a tax deduction, and it grows. It's managed by a group that manages that money. This is similar. You put money into an ABLE Act account. So grandparents want to put money aside for Sally, their granddaughter. That's perfectly good. They can do that. If Sally wants to put her own money in there, Sally can do it, the person with special needs. And so this is fantastic, right? And you get a tax deduction for it. So grandpa and grandma, they need a tax deduction. Let's put some money in. Now there's limits as to how this works. First of all, you can't set up an ABLE Act unless you can prove that you were disabled prior to age 26. This is unfortunate. I wish this was available to everybody, but you have to be able to prove that you were disabled prior to age 26. Number two is you can only put in about 14,000. It may have gone up for inflation, but you can only put in a certain dollar amount every year, and out of everybody. It's not each person can put in 14,000. The total amount that can be put into it and still get the tax advantages and not violate the rules is that dollar amount, like 14,000, or it might be more than that at this point. And so there are some rules we got to follow and keep that up. But the nice thing about the ABLE Act is you don't need a special needs trust. It is often easier to use and easier to access, a lot less regulations, a lot less rules, you're unlikely to be able to, you're gonna end up messing up your Social Security or your medical benefits by using one of these ABLE Acts. You don't need an attorney to monitor it for you. And one of the things I like best about it is we can take money from the special needs trust and fund the ABLE account. And there's a maximum amount you can have in the ABLE account. It can only be $100 and some thousand. You can't put $1 million in an ABLE account. But the idea is, let's say we don't have an ABLE account, or we have an underfunded ABLE account, and we have a special needs trust. Great. Now we can use the ABLE account, which is easier to use, more user-friendly. You can even get a debit card for some of the ABLE accounts, and even sometimes the person themselves can use that debit card. And the idea then is, if we have money in a special needs trust, the ABLE account isn't fully funded, we can every year put money into the ABLE account and make it easier to spend and easier to use. So it's a really good thing and a really positive thing. And the way that it works, one of the things that sometimes financial advisors aren't fond of on this is that it's not privately invested. Okay, so it's a fund set up by individual states. The state maintains that fund. It can't be funded at Merrill Lynch or Edward Jones or whatever else. It can't be funded at your private financial company. It is through the state. It's managed by the state. The good news is, though, that you don't have to choose your state. In fact, the one that we often recommend to folks is the one from Ohio, which is called Stable, S-T-Able. Stable account. So Michigan has its own ABLE account. So you see this map here. The blue states are the ones that have set up these ABLE accounts, and we can choose the one that's most appropriate for you. It doesn't matter where it is. It's not going to make it any more or less convenient to set it up in Ohio than it is to set it up using the Michigan one. We think the Ohio one is more flexible and easier to use, and is just a good setup. In some particular case, it might be that the Georgia one is better, or the Nevada one is better. And so we have all of these options. You notice there's a lot of states that have not set these up, and that's okay too, because any of the residents of those states could set up an ABLE account through one of the other states. So you could be a resident of Texas and you can set up a Michigan ABLE account. You can set up an Ohio ABLE account. So it's a really great thing. It can be worked in conjunction with the special needs trust. And it's true, you don't need an attorney to set up, and you don't need an attorney to monitor it for you and things like that. So it's a great thing. And if the politicians that thought they were hurting lawyers by doing this, they were wrong. This is a positive. Anything that's going to be a positive for our clients, we're going to be happy with. So. All right, last thing to talk about is, how do you set one up? Now, tongue in cheek is, of course, call us. And that's not what I mean here. So you should call us and we will set it up. But when I say tongue in cheek, there's something we have to talk about as to how to set it up, because there's a variety of options. So it can be set up in pretty much any estate planning matter. So if you just have a will, you don't want to do a trust, you can set up a special needs trust as part of your will. Like I said before, I've seen wills that set up a special needs trust in a single paragraph in that will. Okay, now that's a third-party trust, remember. Okay, so you can set up a trust through a will that's called a testamentary trust. You don't need to remember that, that's part of the legalese, but you can set it up through your will. Often it's set up as a sub-trust under your trust. So it says, when I die, it's going to go to this sub-trust. So you set up a trust because you want to avoid probate and get all the other benefits of your trust, your revocable trust. And it's a sub-trust of yours, and that's fine. Often what I like to do, this is sort of better, more thorough, more holistic planning, is set up a standalone trust. So I've been using the example of Sally. Sally is our person with special needs or disabilities or physical restrictions or whatever it is. Okay, so Sally, Mom and Dad want to set up a special needs trust for her because they're going to leave Sally something when they die. Perfect, great. So they could set it up through their will, that's okay. That means only their assets can go into that special needs trust when they die. They could set it up through their trust. That means only their assets can go into that special needs trust through the sub-trust. What I like to do, what I prefer to do, what I recommend for folks is that we actually set up a standalone trust for Sally, standalone special needs trust for Sally. And that way, then mom and dad will be able to leave money to that when they die. So they'll say, you know, Sally's share is going to go to the standalone special needs trust. But then if grandpa and grandma, you know, or uncle and aunt or brother and sister, if they want to leave money for Sally, they all have a mechanism to do that. They don't have to make their own special needs trust as part of their will. They don't have to make their own special needs trust as part of their trust. We have a standalone thing that anybody can put money into. And so if we're going to do it, let's do it right. Let's do it the way that, so if grandpa and grandma want to leave something, you know, even $10,000, I've had folks that, you know, grandpa and grandma left them $20,000. Well, that's going to mess up their benefits. And so it seems like such a small amount of money. Well, now, fortunately, we have this ABLE Act that we could often put most of that money in. Again, not all 20,000, but that's the idea here. So those are the basic ways as to how to set one up. So what are your questions? Let's see if we have any questions. And then Savannah is going to come back on, and she's going to tell you if you have somebody in your life that you feel needs to be protected in this way, absolutely get a hold of us. She's going to talk to you about a free way to interview us and see if we're a right fit for you, and we'll see if you're a right fit for us. And then whether it's about special needs trust or anything else, just getting your planning in order, any kind of crisis matter with regard to long-term care, with regard to your parents, with regard to your sister, just feel free to use this mechanism to get more information and have an opportunity to interview us to see if we're a good fit for you. So Savannah, if you want to give them some instructions.
Absolutely. Thanks, Bob. And as Bob mentioned, we do have a couple of very easy ways for you to get in touch with our team. The first way, of course, is to pick up the phone and just give us a call. Our phone number is 810-694-9000. I have gone ahead and put that phone number in the chat for you now. And again, 810-694-9000. You can also, if you're not sure if today is the best day to call, you don't have time, I want to talk about it, think about it, that's fine. I'm going to also put into the chat a link. This link will let you click and take you to a calendar. When you get to the calendar, you'll choose a day and a time that our team can actually give you a call. When we call, we'll just simply ask you a few questions about your situation, about your goals, what you're looking for, and then you can ask us questions about our firm, about our attorneys, about our process, you know, and we'll answer it as best as we can. And if you decide that you would like to move forward and just learn more, meet with our legal team, then we can schedule an appointment at that time. So there's no risk to calling, no risk or obligation. So I've gone ahead and put that link in the chat. Again, you'll click the link, choose a day and a time, we'll give you a call, or you can just call us now. Thanks so much for joining us today. We look forward to seeing you again next week.